following program is classified G. It's suitable for all ages.
Tonight, can people evade justice post-criminalities by simply crossing borders? Sri Lanka has faced a number of occasions where legal action against individuals residing in different jurisdictions has come up. This is understood in a large field of law known as conflict of laws. The commitment by our country's leadership to move in towards a one country, one law system is also an important contributory factor to this discussion. Has Sri Lanka's understanding of the law of conflicts evolved to the extent of pragmatic action? Or is there a large field that needs to be uncovered in order for justice to be served? Welcome to Law, Land and Liberty, where we are keeping with the promise of bringing to you a contemporary legal topic and breaking it down in the midst of a guest who is an expert in that field. And today we do have indeed a very special guest amongst us, but before that the topic we'll be discussing is the conflicts of laws. Now the reasoning as to why we decided to take this topic up is it has been affecting the country quite a bit in terms of how we have understood how different jurisdictions work and how different legal systems work, and it is important that we iron out certain details. And to give us that understanding and to give us that context, we have with us Reverend Dr. Noel Dias. Thank you so much, Father, for joining us today. He is a lecturer at the Law College of Sri Lanka. He's the founding editor and consultant to the Sri Lanka Journal of International Law, published by the Law Faculty of the University of Colombo, and the chaplain to the Sri Lankan Army. Father, you have been someone who has educated a number of legal minds within this country, now in leadership positions. It's truly an honor to have you amongst our midst. So before we go into our discussion portion, we generally give a breakdown of the topic. The way we'll be approaching this is, first we'll be talking about the basics of the conflict of law. Second, the international commercial relations and the contractual aspect of all of this. Third, the implementation of foreign judgments. And finally, the evolution of the law of conflicts.
My name is Zinat Zakir. I'm a student at Sri Lanka Law College. My question today is, conflict of laws, as the name suggests, is a conflict in many legal systems. Sir, can you explain how this conflict arises and maybe a basic outline of the subject content?
All right, let's get into the discussion, Father. It's a vast area. It's an area that affects almost all parts, all aspects of the discussion when it comes to law. Yeah. And I think the best way to get ourselves, get a proper understanding is to give a big context of the basics of the conflict of laws. Father, how do you approach this topic?
First, I must thank you, Danidu, and also Anuradha, your friend, who introduced me to this program. And also, generally, I preface my lectures, with an anecdote. So, actually, at the commencement of the year, I tell this story about a sailor father who told his sailor son, "Take these 3 bones and you will succeed in life." And there was a guy who was wondering what these 3 bones meant. It is the wishbone, the jawbone, and the backbone. The parable. The parabolic is this: wishbone engulfs the heart, which men and women will be men with a heart. Today we need so much of it. In Christian perspective, we, for purpose of mnemonic, we have underlined as 5 S's. Sainupahak. Satya, Sadharanatva, Samagiya, Samanatmatave, Satyatave. So, kingdom values of, in Buddhism we call the Brahma Vihara. So, we must have those objectives, passion for those values. It is not good enough to have those in your heart. You communicate, and also your words must express what is in your heart. That also not sufficient. Men and women must be men with a backbone. So, you match your words with what you live. So, that little anecdote sort of brings to our subject of conflicts of laws. Conflict of laws deals with several jurisdictions. Because now when we speak of the primary distinction between the laws are categorized into the domestic law and the international law. So therefore, this particular branch of conflict of laws is also called private international law.
Okay.
So therefore, private international law is distinguished from public international law. Public international law deals with interstate relationships, you know, that, so therefore matters like law of treaties, sovereign immunity, all that comes under public international law. And also private international law deals with nationals of two or more jurisdiction. So of course obvious example would be like a matter of contract, you know. Contracts are entered into generally by people, private individuals. So therefore if there is a conflict, you know, between breach of contract, you know, then of course then only our subject comes, which is called conflict of laws or private international law. So I have dealt with the public international law, private international law, and of recent time there is what we call the transnational law. Transnational law deals with state and private individuals. It's also called investment law, you know. So therefore I have given a very brief outline, you know, to distinguish the area in which...
Father, on the outset itself, just to identify in public international law, I believe in public international law and private international law, a lot to coincide with each other, or is there a clear distinction when it comes to...
Clear distinction, you know, because of course now for instance a matter like sovereign immunity, I told you about, you know, the king is sovereign, you know, sovereign is immune from jurisdiction. Those things also sort of, you know, impinge on private international law. But by and large, you know, these two subjects are separate and identifiable, yes.
If we are to move ahead from that point onwards, Father, this contractual aspect, I believe it's a separate...
we are coming into it.
We'll
in fact, now my attempt is to sort of having identified the principles of conflict of laws, time permitting, I would like to deal with its application in the law of contract and also of law of dealing. All depends on the availability of time.
I think you should go ahead and, you know, give us that elaboration as well. Bearing in mind, Father, now the essence of conflicts of law now. Many people would try to understand it in different ways, and would it mean just that two nations having two different sort of policies when it comes to a certain individual, but taking against a certain action maybe. Now we have criminals, we have individuals who try to move away from countries to evade action from a particular state. Are those things that fall under
that particular one would be coming under public international law. So that's called the law of extradition. Extradition, now private international law is private matters, not public matters. So criminal law doesn't come under our subject of conflict of laws, you know. So these are private international law. So that is what we are dealing with.
And as per the key branches, Father, you broke it down into two more, and you mentioned that we have to elaborate on those two lines. Father,
that is about
contract and dealing.
But before that, I would like to come the elements of now I distinguish between the public international law, transnational law, and therefore now when we speak of private international law, there are certain key elements, you know. I would like to sort of, you know, highlight those things.
As a general understanding, the primary point would be on
terminology, for the purpose of terminology. In order, when we speak of private international law, there are certain concepts, you know. So first one is about the called lex fori, F-O-R-I, fori or fori. That is the law that governs a territorial unit. So therefore, there are certain laws that, for instance, land matters, you know, will be governed by the lex fori, where the land is situated. So that's one idea, one concept. Then the other one is lex causae. Causae, the Latin word for cause is causae. So for instance, you know, there's a breach of contract, you know, then of course we'll go to the place where the breach has taken place. So therefore, in conflicts of laws, you will apply in the event of a breach of contract the lex causae. That is where the breach of contract has taken place. So in dealing with conflicts of laws, first one, lex fori is very important in immovable property. And if it is a matter like a breach of contract, then the law lex causae comes into operation. Then we have what we call the lex loci celebrationis. Lex loci celebrationis. That means the place of celebration. For instance, for the determination of the legality of a marriage, then of course you will find out where the marriage was contracted. So the principles, the law that is applicable will be the lex loci celebrationis.
Okay.
Yes.
Father, on this standpoint, if I may ask, I don't know if it's too early to bring up this question.
You can ask any time at any time.
Now, I believe even when we go over the content of conflicts of laws, the selection of a court becomes quite important.
We are coming to that. So that is actually the conflict of laws deals with three main areas. The first one is what you call jurisdiction. So whether the court will have the jurisdiction, the authority. We'll come to that later. But I just want to give you some concepts so that because this will come back to it over and over again. Lex fori, lex causae, lex loci celebrationis. Then we have lex loci delicti. Lex, that is the place where when we are discussing about law of tort or law of delict, then the place where the delict has taken place. So the law that will be applicable in the event of a delict, it is the lex loci delicti, the place. Then the other one is lex citus. We have already said
in the initial part.
Lex loci and the lex fori are something similar, but lex fori is where the law of the court. But lex loci citus is where the land is located. Especially when there is a land dispute, then we will take into consideration the law where the immovable property is located. Another concept is very important, lex domicili, domicile. For private international law, lex domicili is very important.
Where the person is resident, that is.
Yeah. Not only resident, but private international law has more than residence. It is not to the physical presence, but it must be coupled with his intention. For instance, a person can have several residences, but he has only one domicile.
Right.
That is called when, for instance, I am a born Sri Lankan person, my original domicile will dominate. Wherever I go, I can reside in 100 places, but for the purpose of application of law, they will go for lex domicili. That is called the domicile. Right. So those are the important concepts.
Again, Father, if I move back to that initial question of, this is what one would say a messy aspect. There is a huge messy aspect to this where one individual would be in certain countries and we have an entire scenario of trying to identify which law applies and where again the domicile aspect of it. Again, I move back to that question of courts, Father.
Jurisdiction.
So how does that aspect work?
So for the purpose of, for instance, a dispute comes to the Sri Lankan court, So the court will have to determine whether it has jurisdiction, When we speak of jurisdiction, there are threefold jurisdiction by your general understanding of constitutional law, Jurisdiction is the legislative jurisdiction, which is attributed to the legislature. Then of course there is the executive jurisdiction, and the other one is the judicial jurisdiction. So that is what we are. So when the dispute comes before the court will have to determine whether it has jurisdiction. And therefore, for the purpose of determination of jurisdiction, that is what now we are going to come into, called characterization. Now initially, even if you take a domestic law matter, a matter comes before the district court, and the dispute is about an accident. For instance, if it is an accident, it has dual application. One is it's a person causing damage to a person is a criminal offence. So that must go to the magistrate court or the high court.
Within that state.
That's right, within the state. So similarly, in private international law, for the purpose of jurisdiction, the initial question that the court will ask, how do you characterize it? Characterization is very important.
Important aspect.
So therefore, if now we are dealing with private international law, not public international law. So therefore, if the dispute comes before the first of all the lex fori, that is called lex fori, the fori. Forum is the court, So therefore, the forum has to decide whether it has jurisdiction, and having what we call characterized, then only it will have to go to find out if it is a civil matter. Then of course our district court will have jurisdiction even when there is a foreign element. We'll just take an example of a person who has violated the contract between a Sri Lankan and an Indian, and therefore the first limb is settled. That means it's a civil matter, and therefore the court will have jurisdiction. But since there is a foreign element, then the court will have to find out whether it has jurisdiction to entertain a foreign matter, Then only we come into what we call the characterization. We will be doing some case law on that, but
I think
I hope I answered your question.
Yes, you did.
So now let us get a little recap of what we have stated. So we have right at the outset, we distinguished between the public-private international law, and we said that a conflict of laws apply to private international matters.
I think a very good context given to our discussion. Father, we'll take a very short break and we'll be back with more on this same subject of the conflict of laws. Stay with us.
And I'm a law student and a student majoring in international relations. My question is about international commercial relations. How does the law of conflict affect international contractual relations?
Welcome back to Law, Land and Liberty. We are in conversation with Reverend Dr. Noel Dias. Father, you gave a very good context, and I think the division was something that should be made clear to a lot of people within our country as well, the public international law and private international law.
Right.
And it was clear that we are now dealing with, when we deal with conflicts, it's primarily to deal with private international law matters. Father, now given the current status quo within the country, a lot of questions arise with how investors work, how arbitration works, how between nations, all of that works. I think before that, something you ended our discussion previously was on characterization.
So, to your question about jurisdiction, to determine whether the lex fori, forum court, that is a court where the matter comes has jurisdiction, it must first of all characterize, whether it's a criminal matter. If it is a criminal matter, the civil court will not entertain. And then if it is a civil matter, then of course we will have to find out whether it is a matter of contract, or whether it is a succession, or whether it is divorce, or whatever it is. So now we are going to some of the case law. We'll just give an example. For instance, let us say the Sri Lankan court is asked to adjudicate on a matter of inheritance to immovable property. The property is in Sri Lanka. The deceased is a female married in Tibet. The deceased married in Tibet, where polyandry is recognized in Tibetan law. Polyandry. A woman has several husbands. So therefore now, how to classify this polyandry, whether it is a legal concept or illegal concept. Then on one side, the 2 husbands and 3 children. So therefore, if this particular marriage is valid, then of course the children will inherit. If the polyandry is not classified as a non-legal concept, then of course the relation, because it will go by inheritance to not, because the children are not legitimate, and will go to the relations of the husband. So therefore the classification is important. So in order to classify, the courts have set certain guidelines.
When referring classification, Father, something I want to clarify is if you can reference also to, now I think within the introduction of this we actually maybe touched on it a little, because there is a aspect of international law and how it works within our country. We'll talk about foreign judgments later on, but when this classification, for it to occur, are there multilateral sort of treaties or things we are part of, or is there domestic law that we should abide by? How does it?
This is very important. With now for public international law, there are treaties that govern the determination of the dispute. But in private international law, these are all court-made principles. Very few. Now, for instance, we have the enforcement of foreign judgments, and there are treaties. But on matters, like the determination of applicable law, it's all only the conflict rules matters. So therefore, they are evolved by the courts. So
please continue further on those lines.
So therefore, now we started with characterization. For instance, I gave an example, the importance of characterization. So for we will go to another decided case. Ogden versus Ogden, very interesting situation. An English woman and a French man domiciled in France, married in London without the knowledge of their parents. So according to French law, the husband has to be 25 and above. So therefore now the classification has come. This is a case of marriage, and for purpose of marriage there are certain valid requisites. So the law now after the classification, now see what the code does. The facts are clear now, you know. So lady English woman marries a French woman who is without parents' consent, and who is 25 years. Right. The father of the Frenchman took him back to France and got his marriage annulled, because now they got married in London. The father took him and got the marriage of this son invalidated, because in French law it is not valid. Okay. So can I continue? So therefore, then what happens? English woman brought an action in the High Court of England. Now the problem is classification. The matter has now come before the English courts. You know, now if the court will have to find out whether that jurisdiction now that is affirmed, because in civil law matter. Now the second issue is going to be applicable law, but before that they have to do characterization. Now in this characterization, how do you characterize? Now this particular marriage is valid in English law or French law. So therefore now the code.
So that question is answered by, regardless whether it's in France or whether it's in England, the specific code that the question has gone to, they can make that judgment.
The code that determines the characterization is the forum code. Right. You know, of course there are certain principles. Now we have already listed out. If it is an immovable property, lex situs will govern. If it is a lex causa, you know, so those principles we can't discuss right away. So therefore there are certain principles, the conflict of rules has applied, and based on that now lex loci celebratius, that is what determined, you know, for now they have classified this as a marriage principle, and the rule that applies for the validity of marriage is lex loci celebrationis, the place where the marriage has been contracted. And therefore the place that marriage is contracted, 25 years doesn't matter, there's a marriage marriage.
That is what was upheld by the courts in this scenario. All right, Father, moving on to our aspects on now this contractual, this I think a very pertinent case when it comes to contractual obligations. How does that work when it comes to other commercial aspects? How when it comes, I believe this is a separate subject itself. When
we are coming into contract law, but I hope we have ascertained the requisites of the basic principles. I have outlined those rudiments of conflicts of laws like lex causae, lex fori, and now we are coming to the second point of characterization, because based on the characterization only the court can proceed with it has jurisdiction. Once it has jurisdiction, then they go to the next question, what is the applicable law? So
if you can continue there, Father, and also if you can explain to us, in the event different jurisdictions or different countries don't accept that certain courts have certain jurisdiction when decided within another country, are those situations that they would have to face?
Of course. Now, when we come to the case of enforcement of judgments, the enforcing court will have to find out whether the court had jurisdiction. If the enforcing the court that has to enforce the judgment find out that particular court didn't have jurisdiction, then of course it will dismiss, you know. It will not enforce. So
the applicable law aspect, Father, how do you continue?
So therefore, as I said, now we determine that the forum, the court has jurisdiction, and it made the classification accordingly, because this is a matter for marriage, and therefore the applicable law is lex loci celebrationis, and therefore this marriage is valid. But what the French court did was not recognized here. So we'll proceed a little further. It's interesting to find what happened, you know. The court dismissed action on the grounds of lack of jurisdiction. So now the English court says this the place marriage was contracted in England and it was valid in England, therefore the marriage is valid. She married another one. So therefore the first husband, the Frenchman, this lady married another Englishman in 1906. His name is Ogden. So that is how it comes. William Ogden lived with him for some time. Thereafter he filed for nullity on the basis that the woman at the time of marriage had a previous marriage at the time of marriage. So therefore now the court for the initially held that the marriage to the Frenchman was valid, and therefore now the second husband says no, the second, his marriage is void because there was a pre-existing marriage. So the implications of the practical application of conflicts rules is so important, to tell you the truth. I mean, sometimes our local courts don't take sufficient cognizance, of this conflict rules, because today we see many people going abroad and contracts are made. There is, pardon me for telling that, because the courts will have to be more apprised, of the conflict rules. So in this particular case, the second marriage, the lady did not succeed because still the marriage was held to be valid, before the.
So that is how that case ends, Father. So I think a very pertinent issue when it comes to this. Right. How does this entire process then work when it comes to the commercial aspect?
So we'll get into the second idea of contracts. Therefore, for purpose of contract, as we said, there is the formation of a contract and the effect of a contract. So now, can you give me?
You can. Go ahead, please. I think so far the breakdowns pertaining to how we got into exactly the relationships between private international law in between people, in creating contracts is quite clear. Since you did mention that due to globalization and aspects like that, the ability and the presence of contracts between countries, between people of various countries is so vast that it's important to identify this. How do you approach
so therefore, for purpose of conflict rules, therefore having determined the characterization, the court has jurisdiction and the applicable law is that particular law. Now we are going to determine what law is going to apply. In the contract, there are two aspects: the formation of a contract. For the to establish a contract, where the contract is made must be legal. For instance, you can't sort of have a contract to commit a crime. So there are there might be age requirements; those must be fulfilled. Having established that there's a form, the contract is duly formed, then of course the second come about the effect, but it has effects. For the purpose of formation of contract, now the conflict rule says that if the parties have agreed, then of course the law about the law, that particular law will agree. That will be the applicable law. But there might be situations where the intention of the party is not certain. Then they apply what we call the proper law theory, proper law of the contract. Proper law of the contract is the place where the contract has substantial connections with. So, for instance, I will go that I might be able to make it clear when this particular case of
this pertain to identifying which law is affecting a certain case.
What we call for the determination of the validity of a contract, you must find out what law will apply. And in the determination of the applicable law, the court will require that it has to have substantial connections, with substantial connection in terms of the parties, the nature of the contract to be imposed with regard to the enforcement, all those matters. We'll now take an example, Morrow versus Societa Commercial is a decided case in England. We may also refer to this case where the Chancery Division has the same sort of difficulty in determining the proper law of the contract by applying the closest connection with. So therefore, now the court has to determine what is the place where this particular contract has close connection.
Is this also called the real connection, the close real connection test?
But we call closest and substantial connection with the contract. This was an action by plaintiff resident in England against the defendant, a Portuguese company, for damages for breach of contract and for payment of compensation. So therefore, the parties have agreed on a contract and one party breached this. Under the contract, the defendants constituted the plaintiff as the agent in British Isles. So therefore, now in this particular case, the defendant is the plaintiff's agent. England, Scotland, Ireland and Channel Islands for the sale of wines. On the facts, it was conclusively established the Lex Loci contract, which was Portuguese. So therefore, now in this particular, so the contract was to be enforced in several countries. But if you were to take all those things into consideration, the court has no definiteness, and therefore they opted. But the contract which has closest communication connection with this particular contract is the Portuguese law.
Okay.
We'll read a little bit that will make it clarified. As to the place of performance, now therefore this is a sale of liquor, and the plaintiff has assigned the defendant as his agent, and the sales will have to be done in several parts, like in England, Ireland, Wales, and other places. So therefore the performance, the plaintiff's case was all the feats of agency that would induce customers to buy from the defendant company would be performed in England. Customers would be persons trading in England, and it would be England. So that the case for the plaintiff was that English law should apply.
Okay.
But
the location was
but because of the enforcement has to be done in several areas, the court found the Portuguese law is more closer to the contract than the English law.
All right. Father,
I do not know whether I explained myself.
No, you did.
Yeah, because for the purpose of the determination of the proper law of the contract, the court will have to determine what is the place which will make it clearer, and so that
more suitable place.
Suitable, yes, and which has closest contact with the contract.
All right, Father, I think a very important segment that we just passed. We'll take a very short break, and we'll come back and talk a bit about the how in the implementation of foreign judgments, a pretty sensitive area also.
Yeah. What is your
but before that, we have Anuradha Wickramasinghe to give us a take of what exactly happened within the last week. Here's Anuradha Wickramasinghe with Law in the Land.
Thank you, Danidu. Let's take a look as to how the law has worked in our land. The Colombo Commercial High Court extended the enjoining order issued against the Qingdao Seawind Biotech Company and its local agent, preventing payment to the Chinese company for the organic fertilizer shipment until November 19. A fundamental rights petition was filed in the Supreme Court by His Eminence Malcolm Cardinal Ranjit, seeking an order to quash the Gazette notification issued on October 7th regarding the designation of the Muttarajwala wetland as an ecologically sensitive zone and developing it as a Ramsar wetland. The Criminal Investigations Department informed the Supreme Court via the Attorney General's Department that Reverend Cyril Gamini Fernando will not be arrested in connection to a fundamental rights application filed by him with the Supreme Court. That was a look at the major events of how the law had worked in our land. We will now go in for a short commercial break. Danidu will be back after the break.
My name is Ansha Kutlan and I am a PR professional. My question is about the implementation of foreign judgments. How are foreign judgments for personal cases implemented in our country?
Welcome back to Law, Land and Liberty. We are in conversation with Reverend Dr. Noel Dias. Father, again, two very important segments that we passed, and now moving to a more practical, the pragmatic aspect of things, foreign judgments. Now this again, the reason why I called it a sensitive area is now people aren't sure about how foreign judgments affects the nationals of certain other countries, especially when it comes to Sri Lankans or Sri Lankans living abroad. How do you in fact approach this? Because I think the law of delicts or the aspects of tort is something that you want to do touch on as well.
So how before we come to the section on enforcement of foreign judgments, let me sort of touch up a little bit on what we call the law of torts, the application of the conflict rules we decided in terms of contractual law, the determination of the proper law of the contract. And now in the event, for instance, there is a damage, caused to a particular individual or then of course how to determine the application of the law, in applicable law in case of law of delicts. So therefore the landmark case is Phillips versus Ayer. In this there are two requirements. Now for the purpose of the plaintiff to claim damages from the defendant, the plaintiff must establish, that the particular violation is delictual in the place where the action took place or the inaction took place, and also it should be a delict in the place where damage forum. That is, for instance, now in this particular instance, it was a case in Argentina.
So before that, Father, if because we are speaking to the layman pertaining to this, if you can break down what a delict is, and when it comes to law of delict also.
Oh yeah, that might be helpful. So therefore now we both law of contract and law of delict is called in Latin or in Roman languages. The equivalent of that is in tort. In English we call tort for what is delict. Okay. So therefore delict is both are law of obligation. The contract deals with obligation based on consent. So therefore, and in delict, the violation takes place because the law has imposed certain obligations. For instance, the duty of care. When you drive your vehicle, you must be careful. If you drive negligently and cause damage to the other person, irrespective of your consent, you will be found for violation. So you can claim damages. So therefore, now in this particular instance, it's about how the conflict rules will apply with regard to the matters of securing damages for a delict or a tort.
Okay.
Yeah.
Okay.
So there are two principles, as I said, that the place, the action or the inaction. For instance, if you have driven a car and caused damages, then of course that particular action must be delictual in the place where the action took place. Okay. So therefore, that is, we remember we told lex loci delicti, right, when we were trying to define the concept. So in case of delict, therefore it should be a delict, actionable in the place where the action took place, and also it should be actionable where the forum court. For instance, now in this particular instance, the Argentinian crisis, the governor has imposed martial law. As a result, the plaintiff got injured, and after some time, what the governor did, he imposed, they passed a law saying that whatever that happens due to the martial law is non-actionable. Okay. So therefore, in the place where the delict took place, it was not an offence, and therefore when the plaintiff went in England and asked for damages, they said you have no price, because for purpose of delict it should be actionable in the lex loci delicti, where the action has taken place, and also it should be actionable in the forum court. Right. So those are the basic principles with regard to the law of delict.
A very important segue that we can make into how judgments, foreign judgments are in fact put into play.
Right.
Father, what are the important things that we should bear in mind, and what are the principles that actually not more than govern, that give us some form of navigation when it comes to enforcement of judgments? Because a lot of people won't be too clear about it, because a lot of people would understand it as it's sovereign territory. Sri Lanka would be implementing
foreign
based
judgment.
on that. How does that work, Father?
So with regard to the enforcement of foreign judgments, there are two regimes. Okay. One based on what you were asking about treaties. This is one area where there are treaties with regard to the enforcement of judgments, and also therefore which has been long-standing treaties had been domesticated by our legislation by number 4 of 1947, called Enforcement of Foreign Judgments Ordinance. Okay. So therefore that is according to this statute, but for that purpose it has to be a creditor. So therefore judgments which have been turned into a money decree only can be enforced under this particular legislation. Okay. Otherwise, if it is anything like for a divorce or succession and things like that, then we apply what we call the common law rules. Is that clear to you?
That is clear,
very important. So therefore, for the purpose of enforcement of judgment, there are two regimes. One, as I said, under the treaty, and also the ordinance. So therefore, if it is a money decree had been secured by a foreign judgment, you simply bring the decree and deposit in the enforcing court, which is High Court in Sri Lanka, and by a petition, and of course that will be enforced. No issues. Of course, there are certain grounds that will come, which public policy, if that particular judgment is against public policy or it is against the norms of conduct of, then we can. But otherwise, simply by depositing the decree in the court, that will be enforced, because it is this money decree. Money decree will be enforced like that.
On that, please continue, Father, if you have some addition. But something I want to clarify is, I think when referring to the literature that you had also provided to me, something that you made clear was, now people would ask the question, why this takes place, and I think the reasoning that you have provided was between countries in order for that engagement to go ahead.
Of course, there are many legal theories. I didn't want to go into it. One of them is a committee, So therefore, now it is true both in public international law and private international law. Why do we honor other countries' decisions? Because we must have friendly relationships, One of the reasons, why the foreign judgments must be enforced, because we are friends. Countries are friendly countries, and therefore we honor and respect each other. Then the second other theory is about justice, I mean, justice requires that, validly carried out a procedure must be enforced in all countries, So there are several theories we are not going to ask, but one of them is committee. Committee is friendship. Therefore, enforcement of judgments is because we are friendly nations, we need to honor each other. The other one is because of demands of justice, So people must not be left to the whims and fancies of unjust decisions.
True. Father, since we are in the issue, we are actually talking a bit about the judiciary. A clarification that I would like to make is now within our program itself, a question that we had constantly spoken about is which court has the mandate to hear a certain case. So when it comes to this issue of conflicts, are there specific courts, or is it based on where the petition is made?
So when we speak of jurisdiction, Thanidu, there are different strands of jurisdiction. One is territorial jurisdiction, the other is monetary jurisdiction, the third is subject matter. So for instance, for purpose of territory, now if you take the leaving out the private international, we take the domestic courts, there are certain matters come within the Colombo magistrate court will have matters that comes within the Colombo court. Then of course there are certain monetary limits, So if it is now we had what we call the primary courts act, under that certain disputes which are about 150,000, then they go to the primary. So that's a monetary jurisdiction. Then the third one is subject matter jurisdiction, So therefore the private magistrate court will entertain only criminal matters, whereas the district court will entertain only civil matters. So those are the strands of different kinds of jurisdiction.
Father, important clarification made there as well. We'll take a short break and we'll meet in the final segment where we can talk a bit about the aspects that need evolution, or how the evolution process has happened when it comes to law of conflict. Stay with us on Law, Land and Liberty.
My name is and I'm an admissions coordinator. My question is about evolution of law of conflicts. What are the aspects that require evolution in law of conflicts?
Welcome back to Law, Land and Liberty. We are in our last segment and we are in conversation with Reverend Dr. Noel Dias. Father, the last segment we really wanted to talk a bit about the developments and the aspects that require certain refining when it comes to the law of conflicts, given that there are certain vacuums that is present in any country and in any legal system. But Father, I think there was a certain area that you wanted to conclude on when it comes to our previous segment where we were talking about the enforcement of judgments, and we'll continue from there.
So then where we stopped, that is about the enforcement of foreign judgments, which is a money decree. But there are matters like status, for instance, about the divorce or about succession, inheritance and things like that. Then we apply the common law rules. And the requirements are for the enforcing court will see when the judgment, the foreign judgment has been given, whether the defendant had been present, very important. So, so the court will have to determine whether the defendant against whom this judgment will have to be enforced was present in the court, original court. And about the nationality, so if it is the judgment is against a particular national, then of course he will have to ascertain the nationality. Then the third one is the voluntary submission. So therefore, and the defendant has sort of voluntary. So these are the things that the court, the enforcing court will have to see before the judgment is enforced.
Okay.
So if they are satisfied that these matters had been accomplished, then of course the court, but then there are certain reservations also that will apply both for money decrees as well as the status. You know, for instance, there are, if the judgment is against public policy, you know, even though it has been, all those regulations have been followed, for instance, we have public policy requirement, you know, for instance, you know, the respect of religion or culture, things like that. And those matters will be taken. If it is public policy, then of course that particular judgment will not be. And if the court has violated the principles of natural justice, you know, so therefore the voluntary submissions involve that the defendant has been given a chance, audi alteram partem, that in you know that no, before the judgment is given, the court should have jurisdiction, and also the defendant must be sort of secured before the judgment is given. So when those conditions are fulfilled, then the enforcing court will enforce under common law the judgment given by the foreign court.
Father, if we take a step ahead from there and talk a bit about now, as we started this discussion, it was a complex area, as we mentioned, an area that requires that refining. Where do you think those developments need to take place? Where do you think are the sensitive areas? Where do you think we should really focus on?
I briefly initiated Danidhi when I was taking, not to cast aspersions on the Sri Lankan courts. We have a very powerful court system. But with regard to the matters of conflicts of laws, you know, I think of course will have to be more apprised of, you know, because now the people are traveling about, and there are many that comes within the area of conflict rules, and somehow the Sri Lankan courts will have to be more alert to the implementation of the regime. And of course, with regard to like what you have been telling, the need for, there are grey areas, you know, with regard. So therefore, it would be helpful if they come, like in the case of enforcement of foreign judgments. Of course, there is now with regard to the adoption, you know, there is a treaty, you know, foreign adoptions, you know. So like that, you know, if you can have more treaties, you know, which also help determining, clarifying the applicable law, then it will be helpful for the for the accomplishment of justice for the individuals, you know. So these are the areas that the conflict rules will have to evolve and develop, in my understanding.
Father, in conclusion, if we are to take a look a bit about the bigger picture when it comes to the conflict of laws, now moving forward, we see that the countries will be more intertwined. There will be more interaction between these nations. There will be, you know, there will be the number of contracts that will be created will be far more. What should we as a nation, what should we as, you know, the court system should be aware of when it comes to conflicts? What are areas that are really falling into maybe the shadow of, you know, these developments? Where do you think we need to really iron out? Like what I
said earlier, you know, the need for to be more alert, you know, with regard to the conflict rules, but at the same time, you know, now we are, it's a globalized world, as you say. Now there's a talk of one law and one country system. So therefore, whether we could have one law to the whole world, it's a questionable thing. But so while there are definitely differences, you know, while respecting religion, ethnicity and things like that, you can't sort of cut everything into one norm, you know. So that while rights are observed, there is also should be justice and fair play. That's the most important. So it applies also in conflict rules, you know. That's why this leaving entirely to the domestic court for the determination of the rules, if we can have a more unified principles for private international law, that will sort of forge better justice to the people at large.
All right. Father, I think a very, very important discussion. We really learned a lot from from the entire, you know, breakdown you gave us. Reverend Dr. Noel Dias is a lecturer at the Law College of Sri Lanka, the founding editor and consultant to the Sri Lankan Journal of International Law, published by the Law Faculty of the University of Colombo, and a chaplain to the Sri Lankan Army. Thank you so much for giving us this time, Father, and talking with us today.
Such a great joy to have met you, first of all, and also to be part of your Derana TV station.
Thank you so
very much. Everything best, and God bless you. Teruvan Saranai. Yes, be it.
All right. Conflict of laws is a subject area that takes prominence when assessing the legal developments of the 21st century. However, it must be understood that regardless of foreign legal sentiment, what is most important is the protection of the sovereignty of our people. Linguist and philosopher Noam Chomsky once stated that history shows that more often than not, Loss of sovereignty leads to liberalization imposed in the interests of the powerful. An important thought to bear in mind when witnessing the intrusive interests of certain nations in the current status quo. That is all from us here at Law, Land and Liberty. If you had missed today's program, you can watch the entire episode on our YouTube channel, youtube.com/Derana English. Join us again next week as we break down a contemporary legal topic. I'm Dalil Tanwasa. Have a great day.